All right, well, I'd like to welcome everyone to the fifth in our series of 6 regular arbitration breakfasts, which have been taking place during the course of this year and which we hope you'll find instructive. We say good morning to our friends and colleagues in the UK and elsewhere in Europe. Good afternoon to those joining in the UAE, Africa and Mauritius, and good evening to those few of you on this occasion who are joining from Singapore and elsewhere in the Asia Pacific region. With me today are my colleagues Stephen Brown and Daniel Scott, who form part of the arbitration team at Wilberforce Chambers. And in today's briefing, we're going to discuss the impact of the UK's departure from the European Union on international arbitration in the UK. We're going to take a different tack to that adopted in our previous briefings, in that the discussion is directed towards looking at the issues which the UK's departure from the European Union has thrown up so far as UK court proceedings are concerned, and then comparing that position with the untroubled waters of international arbitration in the UK. The central point that we want to highlight is that precisely because arbitration has very largely been kept out of the reach of EU law, in the light of the changes brought about as a result of Brexit, Brexit's provided a boost for London-seated international commercial arbitration and investment arbitrations. The Brexit arrangements have a relevance not simply within the UK and the EU, they have implications also for parties and lawyers throughout the world, not least in terms of the re-establishment of interest in English common law in the Asian common law jurisdictions. We're going to be referring throughout to London arbitration for the simple reason that most international commercial arbitrations and investment treaty arbitrations which take place in the UK do, for better or worse, take place in London. But what we say applies to arbitrations, of course, seated across the United Kingdom. We're very keen, as always, that today should be an exchange of views. We welcome your contributions, and we ask you please to use the Q&A button at the bottom of the screen rather than the chat button to ask questions throughout the session. We're very happy to try and deal with them as we go along, so feel free, if you have questions, not to wait to the end of the discussion. And finally, as usual, for light entertainment, we have a couple of polls during the course of the discussion from which we look forward to your own instinctive views on the questions asked. So, starting with the trade and cooperation agreement between the UK and the European Union. Technically, the European Union lost the UK as a member on the 31st of January 2020, but the 2019 withdrawal agreement between the UK and the EU established that EU law would continue to apply in the UK until the end of 2020, so as to allow negotiations on the future relationship between the two to continue. And that position is enshrined in the UK in the European Union Withdrawal Agreement Act of 2020. After frantic last-minute haggling, which we all remember, those negotiations concluded on Christmas Eve 2020 with the Trade and Cooperation Agreement between the UK and the European Union, which we're going to refer to as the TCA. That was implemented into UK law through the European Union Future Relationship Act 2020, which entered into force on the 1st of January this year. Now, one matter which the TCA did not address, and which is important in today's context, is the whole area of judicial cooperation in civil and commercial matters. So far as the EU is concerned, the UK is now a third country. It's no longer a member state. And that has implications in relation to the application of EU law to such matters as governing law, the taking of evidence in the European Union, the choice of forum, and the recognition and enforcement of judgments.
Thank you, Stuart, and good morning, everybody. Now, as you know, there's a formidable number of statutes and statutory instruments in this area, many of them with long titles. So I'm first going to provide some terminology. Exit day was the day the UK left the EU. And that was originally set out in the European Union Withdrawal Act as being the 31st of October 2019, but it was amended to mean the 31st of January 2020 by some amendment regulations. IP completion day was the day the implementation period ended, being the 31st of December 2020 at 11 p.m. And this is defined in the European Withdrawal Agreement Act 2020. The implementation period was therefore between the 31st of January 2020 and the 31st of December 2020. And this is sometimes also referred to as the transition period. Now, that can be confusing when one considers transitional provisions, which can extend beyond the implementation period. Because originally the legislation worked by reference to exit day, but everything was delayed during the implementation period, many references to exit day have been amended to mean IP completion day. And lastly, retained EU law is the law of the EU retained as UK law at the end of the implementation period. Now, when one cuts through all of that, quite simply, there is a period to the 31st of December 2020 when, as we'll see, nothing changed. And then there's the period from the 1st of January this year when the changes we're going to talk about came into effect. Now, I'm going to look at the pre and post position in relation to jurisdiction enforcement, and then come back to governing law, because basically in that respect, nothing's changed. Now, the pre-IP completion day period is relevant because of the transitional provisions which carry on some of those things into this year. Pre-IP completion day, there was a comprehensive EU-wide system in place governing jurisdiction and enforcement in relation to court proceedings. As you know, there was the Brussels recast regulation regarding jurisdiction and enforcement between EU member states, and there was the Lugano Convention regarding the same matters and mirroring the Brussels regulation between the EU and certain EFTA states. And of course, as you know, also arbitration sat outside of that regime. Further, the EU, since October 2015, has been a party to the Hague Convention on the Choice of Courts 2005, which the UK rejoined in its own right from the 31st of December 2020. Where it applies, it governs jurisdiction and enforcement between contracting states in civil and commercial matters. However, as between the UK and the EU, this itself has certain contentious aspects, which I'll come back to later. Unlike the recast Brussels regulation, the Hague Convention does not cover the position in the absence of party choice. So the position from January 2021 was as follows. The recast Brussels regulation was revoked in the UK. The UK ceased to be a party to the Lugano Convention because its membership was through its membership of the EU. Only the transitional provisions give these instruments any remaining substance, and I will come back to those transitional provisions. The position now, therefore, is that in relation to proceedings commenced from IP completion day, unless the Hague Convention applies, jurisdiction is governed by the common law rules that already apply to non-EU states. Regarding enforcement, the position between England and EU member states, excuse me, absent the application of the Hague Convention, currently falls into one of three categories by reference to the pre-Brussels regime position. First, the Foreign Judgments Reciprocal Enforcement Act 1993 governs the position between England and Austria, Belgium, France, Germany, Italy, Holland, and Norway. Second, the Administration of Justice Act 1920 governs the position between the UK and Cyprus and Malta. Both of these could be revoked by the UK government in relation to EU member states, and it probably will be a point of contention as to whether they have survived being superseded as they were many years ago by the Brussels regime. Thirdly, the position between the UK and any other EU member state is the same as between England and any third state. Judgments would therefore have to be enforced in England by bringing an action on the judgment. And there's a useful summary of this at paragraph 74.0.3 of the White Book. Now, just to finish with the transitional provisions, it's not the case that the recast Brussels regulation is no longer relevant at all, because of certain transitional provisions which provide that proceedings of which a court in any part of the United Kingdom was seized before IP completion day and are not concluded before IP completion day shall still be governed by the recast Brussels regulation. And the same applies to the Lugano Convention. As far as jurisdiction is concerned, this is perhaps of limited importance. The proceedings would have to have been started before IP completion day, and any change to jurisdiction would then be governed any challenge to jurisdiction would then be governed under the recast Brussels regulation. In relation to recognition and enforcement, the recast Brussels regulation continues to apply to judgments given in legal proceedings instituted before the end of the transition period, and to authentic instruments formally drawn up or registered and court settlements approved or concluded before the end of the transition period. In other words, if the proceedings were instituted before 1 January 2021, any judgments subsequently given will still fall under the recast Brussels regulation for enforcement. And this, is, as you would appreciate, could be several years into the future. What does that mean? Well, if it applies, Article 24(5) gives exclusive jurisdiction in proceedings for the enforcement of a judgment to the courts of the member state where the judgment is to be enforced. There are bases upon which the court can refuse recognition enforcement, as set out in Articles 45 and 46. Article 45 sets out the bases in relation to recognition, and Article 46 refers back to them in relation to enforcement. Very briefly, these are A, if recognition would be contrary to public policy, B, where judgment was given in default of appearance, or C, where the judgment is irreconcilable with a judgment given between the same parties in the member states addressed. We'll come back to how one goes about enforcing a judgment in practice to compare that with enforcing an arbitrary award under the New York Convention. Decisions of the CJEU before IP completion day regarding the recast Brussels regulation are binding on the English court. Decision from IP completion day can be taken into account. Now, regarding governing law, as you remember, as you know, Rome I and Rome II have become retained EU law, and therefore from IP completion day, the position on governing law was unchanged, but may now diverge over time. And that's because the EU and the UK may take different approaches to the development of the law in this area. At present, in relation to contractual obligations, the guiding principle is that contract will be governed by the law chosen by the parties, but in the absence of choice, one looks at habitual residence, either of a specified party in certain categories of contract, or outside of those categories, the habitual residence of the party required to give effect to effect the characteristic performance of the contract. In relation to non-contractual obligations, again, the parties can submit to the law of their choice, but absent that, different categories of non-contractual obligations are dealt with individually. The guiding principle in tort, for instance, is that the law is the law of the country in which the damage occurs.
Thanks, Stephen. Good morning, everyone. I'm just going to talk briefly about the Lugano Convention. So the Lugano Convention 2007, or Lugano as I'll refer to it from now on, concerns jurisdiction and enforcement between EU member states and certain EFTA states, namely Iceland, Norway and Switzerland. And it mirrors the provisions of the Brussels Regulation 2001, which was the law before the Brussels Regulation was recast. Now, the UK applied to accede to Lugano in its own right on the 8th of April 2020, and if it's permitted to accede to the Lugano Convention, the UK courts would continue to recognise and enforce judgments of the other contracting states and vice versa. The position between the UK and EU member states would therefore be broadly as it was before the end of the transition period, although without the refinements which were introduced by the recast Brussels regulation. However, for the UK to accede, all the existing contracting states must consent. While Switzerland, Norway and Iceland support the application, the EU itself hasn't yet agreed. And in fact, on the 4th of May 2021, the EU Commission actually recommended that the UK should not be allowed to join because, in the Commission's own words, the UK does not have a particularly close regulatory integration with the EU, and also because the Hague Convention framework, which Stephen's briefly mentioned, is the EU's general approach to judicial cooperation with such third countries as the UK is now perceived to be by the EU. But of course, the Commission is not the decision maker here. The member states and the European Council are the decision makers, and they are reported to be split on the issue. So this is a point where I think we would say, watch this space, because a decision is expected very soon.
So before we actually get that decision, let's have our first poll. The question is, will the European Union allow the United Kingdom to rejoin the Lugano Convention? There's no room for prevarication on this. It's yes or no. So please select one, and we'll see what you think. While you are voting, one's got to bear in mind that politics come into play very much on this. As a matter of pure law, it may be that the UK would be allowed by the EU to join, but given the politics and French fisheries and so on, it's a moot point. And indeed, by a small majority, the view is that the European Union will not allow the United Kingdom to rejoin. Well, let's wait and see if that's right, hopefully in the relatively near future.
Well, that's an interesting result from that poll. So if the EU does block the UK's reaccession to Lugano, there will be a number of areas of uncertainty. As we'll see shortly, for exclusive jurisdiction clauses agreed from 1 January 2021, the Hague Convention would generally apply, so that the courts of EU member states would respect the clauses and resulting judgments. But of course, the Hague Convention will not always apply. For example, there might be a non-exclusive jurisdiction clause, or there may not be a jurisdiction clause at all, in which case the UK and EU courts would apply their own rules relating to jurisdiction and enforcement. There would also be uncertainty where the court of an EU member state has jurisdiction under the recast Brussels regulation as to when it may decline jurisdiction or stay proceedings in favour of the UK court if the UK proceedings are not first in time. So there's going to be uncertainty around parallel proceedings. And whilst this uncertainty, of which there are many other examples, which we just don't have time to mention, remains, clients may well consider that arbitration is the better route to ensuring that their awards can be enforced.
Daniel. Lastly then, of the conventions, I'm going to talk about the Hague Convention, which applies in international cases to exclusive choice of courts agreements in civil and commercial matters. And where it applies, it governs choice of courts and enforcements of judgments of those courts in contracting states. Now, it currently applies in all EU member states, the UK, Mexico, Montenegro, and Singapore. The USA, China, and Ukraine have signed the Hague Convention, but only to express their in-principle intention to become a party. If an exclusive jurisdiction clause is compliant with the requirements of the Hague Convention, the party's choice of jurisdiction will be upheld, and a court in any contracting state will enforce a judgment of any other contracting state. But Hague applies to choice of courts agreements concluded after the convention enters into force in the state of the court chosen in the jurisdiction clause. So the UK government considers that the Hague Convention applies to the UK from the date of its original accession under the umbrella of the EU, which was from the 1st of October 2015, whereas the EU considers that it applies to the UK from when the UK entered into the Hague Convention in its own right, i.e. the 31st of December 2020. So consequently, while the English courts will apply the Hague Convention to determine jurisdiction in respect of agreements entered into from the 1st of October 2015, the courts of the EU may not, and it remains to be seen how that particular problem may be resolved. In relation to formal requirements, where the recast Brussels regulation has special rules in relation to consumer, employment and insurance matter, the Hague Convention simply excludes them.
Now, for Hague Convention purposes, the jurisdiction clause has got to be exclusive, and that's defined to mean that the parties must have chosen the courts of one contracting state, and that's led to a divergence of opinion in relation to so-called asymmetric jurisdiction clauses. Well, what is an asymmetric clause? An asymmetric jurisdiction clause is one which requires one party to sue in a specific jurisdiction while the other has the choice of jurisdictions, and typically one sees those provisions where one party has the economic power in the negotiations, for example in banking and finance transactions. In relation to the recast Brussels regulation, the Court of Appeal in a case called Etihad Airways and Lucas 2020 EWCA Civil 1707 that an asymmetric jurisdiction clause was an exclusive jurisdiction clause insofar as one party had agreed only to sue in one country, and the wider choice given to the other party was a non-exclusive jurisdiction clause. Etihad, however, cast doubt on whether that was the case in relation to the Hague Convention. Without deciding the matter, the Court of Appeal proceeded on the basis that the Hague Convention should probably be interpreted as not applying to asymmetric clauses. Two English first instance judges, again without deciding the matter, have indicated that they could see the force in arguments that asymmetric clauses were within the Hague Convention. In Etihad, the Court of Appeal at paragraph 85 quoted from the explanatory report, which provides that it was agreed by the diplomatic session that the agreement must be exclusive irrespective of the party bringing the proceedings. So agreement of the kind referred to in the previous paragraph, in other words asymmetric agreements, are not exclusive choice of court agreements for the purposes of the convention. Again, another area of uncertainty where it remains to be seen how this will be resolved.
The next thing we're going to consider is enforcement, both of foreign judgments and of arbitral awards in the UK. Enforcement can often be an afterthought in both litigation and arbitration, but it most definitely should not be. Understandably, perhaps, parties at the beginning of any disputes process are focused on putting their best foot forward and on winning the dispute. But that may well prove to be a Pyrrhic victory if the judgment or award cannot then be subsequently recognised and enforced in the party's jurisdiction of choice. So what we're now going to do is consider through a bit of a compare and contrast exercise the differences that parties will face in enforcing a foreign judgment and an arbitral award in the UK. And the basic point that we wish to stress is that Brexit and its consequences have made arbitration more attractive when it comes to enforcement than it was previously. So I'm going to look firstly at the enforcement of foreign judgments. And the best place to start is the former European regime under Brussels recast. And of course, as Stephen has already pointed out, that does continue to apply to some extent under the transitional provisions to European proceedings instituted before 31st December 2020. So it will continue to apply to those proceedings, but of course, there's only a finite amount of those proceedings. So eventually that option as an enforcement route will dry up. As Stephen's already mentioned, the decisions of the European Court before the 31st December 2020 remain binding on the UK courts. And this means that there was and remains considerable juridical certainty when enforcing judgments under the European regime, because there's a rich body of case law interpreting that regime. We've already seen briefly the limited defences to recognition and enforcement under the European regime. The point to take away there is that these exceptions are very limited in scope. The procedure is also very straightforward. It was previously under CPR Part 74, and it still is by virtue of certain transitional and saving provisions, so the procedure is identical. It's a very speedy, efficient and cost-effective procedure, and likewise the procedure for refusal of enforcement that a judgment debtor might wish to pursue. Once registered, a judgment is treated as if it's an English judgment, and that means that parties have the normal suite of enforcement options available to them, as if the judgment had actually been made by the English court. So that's in brief the European regime. Now we're going to look at the post-European regime, if you will. And so there are a number of different regimes here rather than a single one, as Stephen's already alluded to. So the first point is that the enforcement of judgments from courts in EU and EFTA states and proceedings instituted after the 31st December 2020 will be determined by the Hague Convention, where that applies. Otherwise, you have the statutory regime or the common law rules that already apply to the enforcement of judgments from courts in many non-EU countries. And as I'm going to go on to suggest, that's probably going to be the main source of enforcement now in relation to judgments from EU member states. By way of broad overview, a much narrower class of judgments is enforceable under the statutory regime than under the European regime, and enforcement under the common law requires the judgment creditor to commence fresh proceedings to enforce the foreign judgment as a debt. The grounds on which enforcement can be resisted under both the statutory and common law regimes are wider than under the European regime. So just in brief, they are not as efficient on the surface anyway as the European regime. So I'm going to start with the Hague Convention. As we've already touched on, from 31st December 2020, this applies to the enforcement of judgments in England given by the courts of EU states, as well as Mexico, Singapore and Montenegro, where the foreign court had jurisdiction under an exclusive choice of court agreement. As has already been touched on, the Hague Convention has various limitations as a regime for the enforcement of judgment, particularly in comparison with the recast Brussels regulation. A few of these are as follows, which is that the Convention only applies to judgments given by a court designated in a jurisdiction agreement. That jurisdiction agreement must be exclusive. As Stuart's touched on, it may well not apply to asymmetric jurisdiction agreements. The subject matter scope of the convention is more limited, and the grounds for non-recognition are broader under the Hague Convention and under Brussels recast. And finally, Brussels recast provides for enforcement without the need for any declaration of enforceability, whereas the Hague Convention leaves the procedure in this respect to the enforcing state. Now, the procedure for enforcement under the Hague Convention is again to be found in CPR Part 74, specifically at Parts 74.3 to 74.10, which also in fact governs the enforcement of judgments under the 2001 Brussels regulation and under Lugano. In brief, there's a two-stage procedure for enforcement. The first stage is that the judgment creditor applies without notice for the registration of the judgment, and then the judgment debtor, if so advised, files an appeal against registration if they have grounds to do so. So this procedure places the onus on the judgment debtor to take positive action to stop the judgment becoming enforceable. They're not entitled to make any submission on the application for registration, and the court is obliged to register the judgment if the formalities have been complied with. So, as I've said, objections can only therefore be raised at the appeal stage. And much like under Brussels recast, the judgment which is required to be recognised and enforced under the Hague Convention has the same force and effect as if it had been given originally by the registering court, in this case by the English court. The next regime to consider is the statutory regime. As Stephen's already touched on, this is the Administration of Justice Act 1920 and the Foreign Judgments Reciprocal Enforcement Act 1933. The Administration of Justice Act applies to judgments from many countries, but in the case of the EU, it's Malta and Cyprus. Interestingly, enforcement under the Administration of Justice Act is discretionary. It depends on the court considering it just and convenient that the judgment should be enforced in the UK. So that, of course, in itself, whenever the court has a discretion, creates uncertainty for litigants. The Foreign Judgments Act governs the position between England and Austria, Belgium, France, Germany, Italy, Holland, and Norway. But there's a major caveat or red flag here, which is that it remains unclear whether judgments can now be enforced under these statutes. These statutes brought into law a number of treaties or conventions between the UK and the other countries that I've mentioned. But then, of course, the European regime came along and governed enforcement and indeed jurisdiction, etc., and governing law in this area. And so there's an open question as to whether the European regime permanently superseded these agreements and thus these statutes, such that they can't now be revived. And the Law Society has actually recently issued guidance on this very point, saying, perhaps rather unhelpfully, that this is likely to be a topic for litigation. So it's not a settled point. In any event, regardless of whether the statutory regime applies, it's of limited scope and it's clearly less desirable than the European regime. So a couple of brief points as to why that is. Only money judgments are enforceable. So, for example, a foreign injunction wouldn't be enforceable. Also, a foreign judgment will only be enforceable under these statutes if the original court, broadly speaking, had jurisdiction on a territorial or consensual basis. Even though a fresh action isn't required, as it is under the common law, there is a need to obtain a declaration of enforceability. And that means that there are more steps and therefore significantly more trouble and expense than enforcement under the European regime. And just as an example, these issues were considered in a 2014 case called Standard Chartered Bank and Zungeru Power. The reference for that is 2014 EWHC 4714 Queen's Bench Division. And in this case, the court refused registration under the Administration of Justice Act of a Nigerian disclosure order, which was ancillary to a freezing order, because the party to whom the order was directed was neither carrying on business nor ordinarily resident in Nigeria and hadn't agreed to submit to the Nigerian court's jurisdiction. So you can see there that the technicalities related to jurisdiction here and how that affects a party's right to enforce. That was actually a secondary reason in this case, because of course a disclosure order is not a money judgment. So that's actually the main reason that this order couldn't be enforced abroad in this case. There are many defences under the statutory regime, more so than under the European regime. Too many to mention today. However, one defence that's obviously relevant and a pertinent example is that a defence is available if the proceedings were brought in breach of a jurisdiction or an arbitration agreement. In terms of the actual mechanics for enforcement under the statutory regime, This just requires a simple registration of the foreign judgment, a little bit like under Brussels recast, without the need to commence fresh action and without notice to the judgment debtor until registration has been ordered. The onus is then therefore on the judgment debtor to apply to set registration aside if they so wish. So it follows therefore that this enforcement procedure is quicker and more efficient and indeed cheaper than the common law procedure, but it's probably overall less satisfactory than under the European regime. Just briefly in terms of timings for bringing enforcement applications under these statutes, one generally has 12 months to make an application to the High Court from the date of judgment under the Administration of Justice Act, and the equivalent period under the Foreign Judgments Act is 6 years. So that brings us to the common law regime. And this is the regime that now applies to the enforcement of EU or EFTA state judgments in proceedings commenced since the 31st of December 2020, with a couple of exceptions, and may include the countries as well covered by the statutory regime, if the answer is that that regime has now been superseded and can't be revived. In terms of exceptions, obviously, as I've already touched on, if the Hague Convention applies, that would govern the position rather than the common law regime. But as I've already said, there are some fairly significant limitations to the Hague Convention regime. But in short, and in the absence of any further agreement between the UK and the EU, it's now the common law regime that's most likely to be relevant when we're looking at the enforcement of EU judgments. And this regime differs from the European regime in a number of important respects. In order to be enforceable at common law, there are a number of key points about the judgment. The first is that it must be final and conclusive in the court which pronounced it. Again, like under the statutory regime, it has to be for a sum of money, although not for taxes, fines, or other penalties. But again, that means that foreign injunctions wouldn't be enforceable at common law. And finally, it has to be a judgment on the merits. A foreign judgment which is final and conclusive on the merits obviously can't be attacked for error of fact or law. But again, there are various matters, again, which go probably beyond the scope of this talk and what we've got time for, that might enable the judgment debtor to resist enforcement. But as with the statutory regime, another matter that affords a potential defence to the judgment debtor is where proceedings are brought contrary to a jurisdiction or arbitration agreement. In terms of the actual mechanics for enforcement at common law, a judgment creates an obligation which can be enforced as a debt in fresh legal proceedings. Now, that, of course, is markedly different to the other regimes you've considered, because rather than having a mechanical procedure just by application to enforce a judgment, one actually has to commence fresh proceedings, and that brings with it all sorts of potential issues. For example, it may be necessary to serve the proceedings out of the jurisdiction, and so parties will then have to consider whether it's necessary to obtain the permission of the court to do so. Albeit under the CPR Practice Direction 6B, paragraph 3.1, subpara 10, that does provide a separate ground or gateway for service out of the jurisdiction where a claim is made to enforce a foreign judgment. Now, the creditors will generally be able to obtain summary judgment on the basis that there's no defence to the claim, which is just a debt claim for the enforcement of a money judgment. The English court also has power to award interest on a foreign judgment, even if the foreign court has no power to do so. And indeed, bearing in mind that these are now fresh proceedings in England, it also follows that if the judgment debtor fails to acknowledge service or to file a defence, it's also likely to be possible to obtain default judgment. So by way of conclusion, on the enforcement of EU and EFTA judgments. The European regime was speedy, wide-ranging and fairly straightforward to apply, also benefiting, as we've seen, from juridical certainty and a rich body of case law. The other regimes now, as they exist as we look into the post-Brexit future, represent something of an unfortunate mishmash, which don't necessarily cohere with each other, and they're narrower in scope, afford more opportunity for defence, and likely slower and more expensive than the European regime. And that applies especially for enforcement at common law.
So how does that mishmash, as Daniel described it, contrast with the enforcement of foreign arbitration awards? In short, so far as foreign arbitration awards are concerned, nothing has changed, precisely because, as I said at the outset, this area was always kept out of the reach of European Union law and therefore out of the reach of Brexit. The New York Convention on the enforcement recognition of arbitral awards, it has over 160 signatories, significantly greater than the number of countries with which the UK currently has reciprocal judgment recognition and enforcement arrangements. And there's a fundamental difference between the terms recognition and enforcement. Recognition means the acceptance of a New York Convention award as having the same effect as a domestic award. The award may accordingly be relied on by way of defence, set off or otherwise in any legal proceedings in England and Wales or Northern Ireland. That's under the provisions of the Arbitration Act 1996. Enforcement, on the other hand, means giving an award the same effect as a domestic court judgment. The court is not ordering execution measures, but merely issuing a declaration of enforceability, which then serves as the official basis of further execution. Once an award's been declared to be enforceable in the same manner as a court judgment, the various enforcement procedures available to a judgment creditor under the civil procedure rules become available to the award creditor. And it's in practice often very important to take a decision as to whether to apply for enforcement of the award or simply leave things as at the recognition level. As I just mentioned, an award may be recognised without being enforced, but if the award is to be enforced, it must necessarily first be recognised by the court ordering the enforcement. An enforcing party may also seek the court's permission to enter judgment in terms of the award. In a case called ASM Shipping in 2007, the court affirmed the distinction between permission to enforce and entering judgment in terms of the award. A failure to honour the award may be a contempt of court in the latter case, but not the former. Now, the New York Convention, as I'm sure you'll know, is widely recognised as a foundation instrument of international arbitration. Signatory states agree that they will recognise and enforce arbitral awards made in the territory of a state other than the state where the recognition and enforcement of the award is sought. Of course, not all foreign awards are enforceable under the New York Convention, but for the purposes of the compare and contrast exercise that we're currently engaged in, we'll limit ourselves to considering enforcement under the Convention, which is by far the easiest method of enforcing. The defences to enforcement under Section 103 of the Arbitration Act, first of all. Section 103 starts from the default position that recognition and enforcement of a New York Convention award shall not be refused except in the following cases. And it then goes on to set out those grounds, which we don't have time to cover in detail here. And the court has a discretion to enforce an award, even if one of the grounds set out are established. The available defences are limited. A party to the arbitration agreement was under some incapacity. The arbitration agreement wasn't valid under the law to which the parties subjected it, or the law where the country was, or where the award was made. A party wasn't given proper notice of the appointment of the arbitrator or of the arbitration proceedings. The award deals with a difference not contemplated for or not falling within the terms of the submission to arbitration. The composition of the arbitral procedure wasn't in accordance with the parties' agreement, or the award had not yet become binding on the parties. Finally, the award is in respect of a matter not capable of settlement by arbitration, and enforcement or recognition would be contrary to public policy. And for those of you who were taking part in the webinar on the Betamax case, the first of the breakfast briefings that we did, that was a topic which was covered there and which is on YouTube at the moment. The next thing to consider is the procedure for enforcement. Very straightforward. The award debtor applies without notice and on paper for an order giving permission to enforce, and if the court grants the order, the defendant has a very limited time in which to apply to set it aside. The court will either make the order for enforcement on a without notice basis, in which case the order must state the right of the award debtor to apply to set the order aside. If the court wishes to hear submissions from the award debtor, it must specify the parties to the arbitration on whom the arbitration claim form must be served. In a case called Norsk Hydro in 2002 in the Commercial Court, it was said that there's an important policy interest reflected in the UK's treaty obligations in ensuring the effective and speedy enforcement of such international arbitration awards, but the corollary is that the task of the enforcing court should be as mechanistic as possible. And the judgment in that case notes that the process of enforcement under the New York Convention simply requires the court to give judgment in terms of the award. It doesn't permit a review of the award itself. An order providing for the enforcement must follow the award. So just to pull all the strings that we've been discussing at some length together, it should be self-evident from what we've been saying that enforcing a foreign arbitral award under the New York Convention is significantly easier than enforcing a European judgment under the post-transition period regime. It's probably moot to consider whether enforcement under the Convention is or was easier than enforcement under the European regime under Brussels recast, but both of those methods of enforcement are quick, mechanical and certain. The loss to litigants of the European regime from an enforcement perspective, in our view, makes arbitration therefore even more attractive than it was previously. And that's added to by the fact that there remains so much uncertainty in the areas we've been touching on about how exactly the jurisprudence and mechanics around the enforcement of foreign judgments will change post-Brexit. The replacement of the recast Brussels regulation and Lugano regimes by the Hague Convention risks introducing uncertainty for litigants. One would hope that the new mix of rules will in practice not affect materially the circumstances in which English and EU courts would determine their competence in particular matters and their recognition and enforcement of each other's judgments. But that is a hope, hopefully not a vain hope. It's certainly not a guarantee.
We're now going to look very briefly at the implications of the end of the transition period on the service of the claim form and arguments and on the taking of evidence. As is consistent with our general theme, Brexit has inevitably complicated the status quo in this area, which is in contrast to arbitration, which remains basically untouched. So, service of proceedings. So far as the service of court proceedings is concerned, following the revocation in the UK of the EU service regulation, it's likely that serving documents in English proceedings upon parties in EU member states will be less efficient and therefore inevitably more expensive. And so we're of the view that where parties in the UK are negotiating a contract, for example, with a counterparty in the EU, it's more important than ever to consider agreeing an agent for a service of process clause in order to avoid the need to effect service of proceedings outside the jurisdiction. Now, it should also be said that the UK is a contracting party to the Hague Service Convention in its own right, and that convention continues to apply after the end of the transition period, and indeed will govern most requests for service of documents in English proceedings upon parties in EU member states. But whilst the Hague Service Convention is similar to the EU service regulation, it's not as modern, and it's likely to be less efficient and therefore more expensive as a procedure for service.
Thank you, Daniel. I'd say the same in relation to the taking of evidence. The EU regime under the taking of evidence regulation has ceased to apply, and one has to fall back on the Hague Convention on the taking of evidence abroad in civil and commercial matters. And quite simply, it's 50 years old. It's less modern than the system that existed while we were part of the EU. Stuart.
So just to recap briefly, arbitration proceedings were always excluded from the scope of the recast Brussels regulation and the Lugano Convention, and hence the absence of provisions in the TCA on judicial cooperation in civil and commercial matters, and the uncertainties following Brexit in relation to court proceedings, including such matters as taking of evidence and the service of proceedings, have had no negative impact at all on London arbitration. The significant positive impact is that the well-established regimes governing arbitration remain unchanged and provide ongoing certainty. For example, since arbitration is of course consensual, the process of dispute resolution by arbitration will be determined by the parties' arbitration agreement, supplemented usually by the rules of one of the recognized arbitral institutions such as the LCIA, ICC, HKIAC, SIAC, or by the UNCITRAL rules. The arbitration agreement will identify the seat of the arbitration, accordingly which court will be the supervising court, and which systems of law will govern the arbitral proceedings and challenges to an arbitral award. In view of the ability to have arbitration awards recognized and enforced throughout the world, including within the EU under the New York Convention, London arbitration has become an even more attractive means of dispute resolution, so we would suggest, than English court proceedings, and will involve fewer risks for the contracting parties, all of course in addition to the usual advantages of arbitration such as party autonomy, privacy, neutrality, and the limited scope for a challenge to an arbitral award. I want to add now a few words before we conclude about investment arbitration. The TCA includes provisions on investment protection, but it's restrictive. On the plus side, it guarantees non-discrimination in that each party undertakes to provide the investors of the other with treatment which is no less favourable than that granted to its own investors or third country investors. And it also contains a denial of benefits clause, which is designed to exclude from treaty provisions the nationals of third states who, through mailbox or shell companies, seek to benefit from provisions that the state parties to the treaty did not intend to grant them. But on the negative side, and in stark contrast to other investment treaties which the EU has signed with other countries, it does not provide for equal and fair treatment, full protection and security or expropriation. The definition of an investor is restrictive in that it requires that person to be carrying out substantive business operations in his home state, thereby creating an additional jurisdictional obstacle to an aggrieved investor. And there's no investment tribunal to determine directly an aggrieved investor's claim. Unusually, the investor instead is going to have to persuade the United Kingdom or the EU, as the case may be, to take up its case with the other party to the TCA. One particular unresolved issue concerns the status now of the 11 bilateral investment treaties between the UK and individual EU member states, which provide for direct investor-state dispute resolution, a matter on which the TCA is silent. Do they remain in force because they've become extra-community BITs, or else are their dispute resolution provisions incompatible with EU law? Our view is that these dispute resolution provisions remain in force, but I have to say the position is unclear. So far as the resolution of disputes under the TCA itself is concerned, as between the UK and the EU, these now fall to be determined by a consultation process, followed by ad hoc arbitration if the dispute remains unresolved. So just before we wrap up today's talk, our final poll, will the United Kingdom's departure from the EU be a boost to London arbitration? That should be coming up on the screen now. Will the UK's departure from the EU be a boost to London arbitration? Yes, no, or no difference. I think in many ways that may depend on the advice which potential parties to disputes are given by their legal advisors. But let's see what the panelists, what do you think? Well, I think we've persuaded people today because there's quite a strong majority in favour of the UK's departure being a boost to London arbitration. At least there's some advantages in having left the European Union, but that's a personal view. So, ladies and gentlemen, that brings us to the end of today's talk. We hope you found it useful. If there are any questions you have arising out of it, or you'd like detailed citations of the cases, feel free to email any of us directly. We welcome your thoughts and comments, and indeed any suggestions for future briefings.